nothing more fun in a symposium than having speakers disagree and discuss. That's what it's all about. It's all about the speakers, you know. So I thought that was awesome.
Thank you. Yes. Welcome, everyone. I'm really happy to introduce our final speaker, who is our keynote speaker, Professor Orly Lobel. Orly, to get this right, Orly is the Weckstein Professor of Labor and Employment Law at University of San Diego School of Law. So employment and labor, that's a lot of what Professor Lobel does, but then she really thinks about how does that apply in the intersection of intellectual property, intersection of healthcare, government regulation, and other administrative law. She has been really a prolific author over the past 10 years, writing in all these areas and really groundbreaking work. And her 2013 book as government officials and others, and went some distance in shaping how administrators in the government think about how we should deal with this relationship, this kind of relationship we've been talking about today between employers and employees, and what restrictions are appropriate to place on employees and which ones are not, and what are the broader policy implications of that. And so I've always been a fan of her work, and so I'm really glad that she was willing to come out to be our keynote speaker today. And so without further ado, Professor Lobel.
Thank you, Dennis, for this kind introduction, and thank you to the organizers. This is such a timely conference. Really, so many of the questions that we're asking are still, unsettled. So we are shaping the law just by having this conference. And now there are these copycats. After accepting this invitation, I now am scheduled to do some other around the country conferences about the Defend Trade Secret Act. But really, we have the first mover advantage here. So I think it's great that the better law review is going to do the first symposium after it was enacted, and it's really quite exciting. For me, the questions about the Defend Trade Secret Act are really not simply about what exactly is defined within the scope of trade secrecy and what is misappropriation. But it's really about how trade secret law and policy fits within the bigger picture of innovation policy and competition law and economic development and growth. And when we're in these fields of intellectual property in general and innovation policy, we're always in the world of line drawing. We're always trying to figure out whether we're really achieving the goals that the Constitution mandates of progress in arts and sciences, whether we're promoting new technologies and more competition and more investment, or whether some lines that we're drawing are not achieving it, whether we're stifling in some ways those very goals that we're trying to achieve. So when we place trade secrets within the larger kind of intellectual property ecosystem, I think it's pretty powerful to understand how trade secrets is sort of that big brush tool that carries over while insiders are working within a firm and then beyond when they leave a firm. So in a lot of these other pillars, if you think about what the Patent Act tells us about who owns inventions when we're in a hired to invent context, or the Copyright Act tells us that about work for hire, there's usually some kind of enclosure while we're in the organization, but then those doctrines don't necessarily carry over when we move. That's where the role of contract comes in, and it's layered over the statutory provisions. Same with the fiduciary duties and the duties of loyalty that exist within an organization. If we want to extend that, we use it post-employment. We use the tools of covenants not to compete. But trade secrets has this kind of powerful running across forever. Anytime somebody is exposed as an insider to information, they have, by that very context, a duty to continue to keep that secret, and trade secret law kicks in. And still there is layering of statutory provisions. NDAs, as Peter Rennell said, has become really standard in employment and beyond relationships, licensing relationships, subcontracting, independent contracting relationships. And we have a whole statutory scheme that, as we know now, is both a state and a federal statutory scheme, and we have a criminal and a civil side to it. And I think the questions that have been really interesting to me is how everything fits in when we think now about these as complementaries and not just alternatives. So I've been thinking about these questions. So in my book, Talent Wants to Be Free, I looked at kind of some of these schemes, and this is in the book in Korean and in Romanian, so some of the foreign translations. And I've been thinking about it comparatively as well. And one of the things that I've tried, and I think we ought to continue to try to do, and with trade secrets, it's especially important, but it's also especially hard to do the actual research, empirical research, to figure out how to do this line drawing. Why is it especially hard? Because we don't have the paper trail that patent law offers us with filing for patents. We don't have the exposure by its very definition when we're keeping things secret. Most of the empirical research about trade secrets has really been just survey research, which is in a lot of ways overcounting, undercounting in some ways, and it has its own problems. But I think what is really important to try to model is how there are different effects of what happens when we draw the lines of more controls versus more knowledge flow. So a lot of my research has been kind of a response to what I call the orthodox model of that's pervaded not just trade secrecy, but also in a lot of ways intellectual property at large, that the more we have control, the more we'll see investment, the more confidence corporations will have to invest, and they'll recoup their investment. And as so many, including many in this room, have contributed to the discussion about these questions, intellectual property has always been about balance, because we want to create incentives, initial incentives of investment by rewarding those investors, but we also want to allow flow, and we want to allow exchanges, and we want to allow the building upon the shoulders of giants and the usage of that knowledge after the fact. So we have to think about these models in a much more dynamic way of initial investment, ex ante, and then repeat gains of externalities, positive externalities, as the economists would describe it, of spillovers of knowledge flowing in the market and having that effect of growth. And also understanding that organizations are more than just kind of a black box, and if we pierce through that, you understand that people are making choices about their own investment depending on how much they feel that they have a stake in whatever they're investing. So if you think about human capital as a resource, it's also, it's not just a resource, it's a human resource. And if employees know that they can't take any of their know-how after they leave, then we might see a disincentive to invest in that resource. So before I look at some of what we know and the empirics and the new developments with the Defense Trade Secret Act, I want to tell you a little secret about myself. So my very first career before becoming a law professor, before becoming an attorney, before clerking, was as a military intelligence commander. So I actually want to tell you that I have a very deep appreciation to what secrets are and to keeping secrets, real secrets, secret, national secret, secret. And so what was really interesting about my service in the Israeli Defense Forces as a military intelligence commander was that everything that I ever wrote and researched and exchanged, we marked as confidential and we couldn't talk about it outside. But we also very much knew that everything else was free for us to then use when we get out of the Army. And full teams of my fellow commanders actually in my unit left and started these renowned companies now that were sold to Silicon Valley. So Checkpoint started with people from my group, and Waze recently sold, for $1 billion to Google. These are all Israeli companies that start from some military groups that are very technically savvy, and the Army and the government and the startup ecosystem has always been very encouraging of that story of some things that are national security for sure are secret, but everything else is sort of flowing in the market to create this miracle of startups. And when you look back at Silicon Valley in the early days, you see a similar story where even though we don't enforce non-competes in California, we've always had trade secret law, but not everything that could have been litigated was litigated, and also some of the ways that the Uniform Trade Secret Act was interpreted in California was more limited than in other states. And there is more and more evidence that part of the Silicon Valley miracle has been attributed to the fact that we allowed a lot of flow and whole teams to move around and form new ventures that eventually actually provided a win-win to everybody in the region. The industry as a whole moved quickly, more rapidly forward with this culture of some things are certainly deemed secret, but other things are, most of the things are free to be built upon. So in a lot of ways, times have changed in where we draw the lines and how we balance between the fences and the flow. So times have changed, and in some ways I was thinking, how did it change? Maybe this is me as a military commander, this is me as a professor, so that's one way, just sitting in at my computer. And this is, actually in Seoul, in Korea, when my book came out in Korean, Samsung and Seoul National University invited me to talk about these issues, and this is actually at Samsung. I'm holding my little gift, which turned out to be a Samsung smartphone, although I was keeping my time on my iPhone, so it was a little embarrassing. But this has really motivated me to think about what is going on with recent developments, and I can provide these references later of various ways that we can attack these questions using economic models, empirical insights, experimental insights, and mining through developments in the statutory and the case law developments. And it's been quite exciting because this past summer I was invited to the White House to present Talent Wants to Be Free and to talk to people from the Treasury Department, from the President's policy team, from the Department of Justice and the Department of Labor about non-competes and trade secrets, and whether we're doing everything that we can for innovation policy. So this was in August, and then as part of a working group of the White House, we issued a call to action to the states in October saying, definitely with non-competes, we're going overboard. And maybe also with a lot of NDAs that just try to say that everything is secret, maybe that's impeding some of what we're trying to achieve. These questions also have been coming up globally, and this is at the UN in Austria, in Vienna, where I was part of a working group on, we issued a UN report on connectivity of countries and what these kinds of human capital regimes and laws do to the ability of people to connect on a global level and to migrate, to work in other countries, to win the global talent wars and the kind of brain drain, brain gain conversation. And it's not a coincidence that the Defend Trade Secret Act was enacted at the very same month as the EU's new directive on trade secrecy. So it's really part of a world conversation about do we need to upgrade our trade secret laws, who's winning, who's losing. So these questions have to be asked at a regional level, at an industry level. So for the journals, questions of incumbents versus startups and entrepreneurship, but also at a global level of economic development, and who are the kind of threats, maybe the Dragon Valley, as it's often referred to, versus the United States. So when we place all of these questions within this new secrecy ecology, we have to understand the Defend Trade Secret Act as part of a broader push to augment the state of trade secrecy laws and the kind of the walls and fences that are available tools. We see not only the passage of this Trade Secret Act, but statutory changes that are made on the Economic Espionage Act just in the past 5 years. And I'll show this in a couple of statutes that have really augmented those criminal protections. We see courts providing broader interpretations of those trade secrecy provisions, and we see increased activity in litigation and criminal prosecution. And so the question and the new risk that is posed is whether, instead of we're actually protecting what we value very much, which is leadership in science and technology, we have to ask whether we're altering in some way or perversely impeding the creative environment that we so much value in ways that chill progress. So what I want to do is kind of show you these questions from multiple perspectives, from the perspective of innovation and entrepreneurship, from the question of global exchanges and kind of foreign relations and migration, from the perspective of university research that we value so much, and I think is kind of a unique place of developing knowledge and the building blocks of information, and from job mobility perspectives and the workplace, which is very near and dear to me, and economic growth at large. And all of these questions, I think, can be mapped onto the fact that trade secret law has always been kind of schizophrenic. It has multiple identities, right? It is a pillar of intellectual property law, and in the first panel today, it was said that it's no longer the stepchild or the neglected orphan of the four pillars of intellectual property law, because now it's a federal law and so strong. But it's always been sort of in those four pillars. It's also, though, a tort of unfair business practices, And that's where we get its origins in the restatement. And it's also a pillar, I think, it's a very important component of contract law and employment law in particular. And all of those aspects really tell us why we have to, every time we change the boundaries, every time we try to draw the lines right, we're changing something in all of those relationships of, for example, whether companies will choose to patent more versus to trade, to keep something secret. The balance might shift. Whether there's going to be more job mobility and employment, bargaining power and movement and good fit between recruiters and job seekers from a contractual perspective. And then finally, from a competition perspective, whether we're going to see ability of incumbents to control markets more or new entries to form more quickly. So from an IP perspective, trade secrets, in some ways, it's always been the weakest and the strongest. So it is the broadest in scope in terms of what it enables to include within it. Very, very broad language. In the morning, it was Mark saying in the book that he had 500 examples of trade. It really can include anything. Very, very, very low threshold, no threshold really to keeping something secret as long as it's secret and you take reasonable measures to keep it so. So in that sense, if you think about intellectual property being the law of intangibles, it moves us the most into the world of intangible because it can be something that's completely in your mind. It can be something that's very, very abstract. So all of those thresholds that we have for patent eligibility really don't kick in. It's also very easy. It's a do-it-yourself, low-cost protection. And it doesn't have that trade-off of enabling and disclosing the technology, and then once a patent expires, you have that in the public domain. So it doesn't have that. It really can theoretically last forever and ever. To litigate against somebody who's misappropriating your trade secrets is pretty cheap. It's not cheap, but it's relatively inexpensive if you compare it to some other intellectual property litigation. But at the same time, it's also always been considered the weakest form of intellectual property because it has always been purposely leaky. And the way it's been leaky is that we know that it allows independent discovery, allows reverse engineering, and a series of fair practices that have always been understood to be fair game in the trade secret world. So taking away with you kind of basic know-how that's known in the industry, something that's one's general skills, conducting market intelligence, and anything that can be detected from public sources or public monitoring or viewing was all fair game. And so that leakage has always been understood as part of the reasoning and part of the balance of trade secrets. They're very strong in some ways, but they're that strong because they are weak in how much they can be protected. And indeed, in the seminal Kiwani case, where the Supreme Court said that state trade secret laws are not preempted by patent law, they emphasized the fact that trade secrecy is a weak protection. It assumed that the public domain is always going to be very large. that knowledge is not going to be taken out of it by trade secrecy. They reasoned that trade secrets are so vulnerable that the possibility, this is a quote from the Supreme Court, the possibility that an inventor who believes his invention meets the standard of patentability will sit back, rely on trade secret law, is remote indeed. Well, it's not that remote anymore, as we know. And it's not that remote for not just because we've been strengthening Trade Secrets Act, but as others have mentioned today, there's also a lot of questions about patent eligibility on software, in biotech, in healthcare, in business models, and all of these questions. And so it's sort of a push and pull of how that balance has changed. But what we've been seeing in terms of strengthening trade secrecy is that just in the past 5 years, other than or beyond passing the Defend Trade Secret Act, the Economic Espionage Act was amended twice. We don't usually see Congress reacting so quickly to, in a relatively new law, to the way that the courts have been interpreting the act. So first in 2012, the Economic Espionage Penalty Enhancement Act increased the penalties, the fines and the incarceration terms. Substantively, there was an expanded definition of misappropriation. So it made sure that we understand that there doesn't need to be actual harm or actual completion of the crime, but even just taking something and intending to use it was sufficient. So attempts were sufficient for criminal prosecution as well. The definition of trade secrets itself was amended to include not only secrets that are in products used in interstate commerce, but also for services used in interstate commerce. So this was a response to Goldman Sachs' call that all of their software should be fine under the Economic Espionage Act for prosecution if anybody touches whatever algorithms they have and computer code, even though they don't sell anything in the market except for the money market. So that's the Theft of Trade Secret Clarification Act. And we've also seen, when I say we, Rochelle Dreyfus and I have mined these prosecutorial activities since the beginning, since 1996 to now, and we've seen a huge influx in the number of cases that are being taken on, but very importantly, not just the numbers of actual cases that eventually go into prosecution, but the number of investigations, the scope of public and private coordination, so the FBI activities, the pressures that are being put on private industry and public governments and organizations internally and externally. And very much this message that trade secrecy is now part of national security, not just military secrets, but really the FBI cares about anything from university research to biotech to agriculture, everything. What is, I guess, Rosa Brooks' book, that everything became the military and the military became everything? It's sort of that kind of thing. And so we've mined, when Rochelle and I did research, we looked at some of these recent reports that have been coordinated by government, reports to Congress about industrial espionage. And the FBI has now defined trade secrecy and economic espionage as second to nothing but terrorism. So it's the number 2 goal and important subject that they work on. And we've seen a trilogy of Hollywood-style films being produced by the FBI for the purpose of educating the private industry about the importance of protecting, fencing, reporting any kind of leakage of your secrets. The company Man is one of them. And they did a whole Hollywood launch about it. And you see here, kind of these wanted signs, ads put out by the FBI. And here, so this is one aspect that I want to draw your attention to. Here it's very clear that in this wanted ad, it's not just any potential spies or people former employees who took trade secrets, but it's a very specific national origin. So China appears very, very prominently in all of these reports. And the media also reports in very similar ways. The Aleynikov case, which was completely a domestic case. Sergei Aleynikov was a programmer for Goldman Sachs. He had been here for 20 years, an MIT grad, a whiz kid, was moving to another American company, had a home in New Jersey and then a wife and 3 kids. He's reported as being the Russian spy who took something from Goldman Sachs. This is Michael Lewis, talks about this in his book Flash Boys, of how is it that the only person that was actually prosecuted after the big economic crisis is somebody who took something from Goldman Sachs, and none of the improprieties of that Goldman Sachs was engaging in were ever brought to trial. And so one of the things that we have to think about is effects of false positives and kind of the chilling. So in general, a lot of the thinking that we have to do when we're thinking about the economic effects of some of these laws is not just counting the number of cases that are brought, but the chilling effect and the behavioral changes that are affected when we have these paradigmatic, cases and iconic, messages that are sent throughout the system. And so this is 2015. One case, for example, of Sherry Chen, very typical naturalized Chinese American who goes back every year to visit her family. I go back to Israel every year to visit my family, and you don't know if I'm Mossad or not, but I'm not. But I have to be careful now. I am not a citizen, but she was a citizen. She is a citizen here. I am not, and it just raises these red flags, as it has been raising red flags to so many employers. But there's really nothing in her case, and suddenly, after she's investigated for several months and goes through hell and is fired, there's nothing in the file that suggests anything that she did. And Peter Toren talks about this case. He's a former prosecutor in the Justice Department, and he says they came across a person of Chinese descent and a little bit of evidence that they may have been trying to benefit the Chinese government, but there wasn't, eventually there wasn't anything. But it's clear there was a little bit of a Red Scare and racism involved. And Mark Resch, another former Justice Department prosecutor, says the government thought they had struck gold in this case. The facts didn't quite meet the law here. If you're looking everywhere for spies, you will find spies everywhere, even where they don't exist. And after the media coverage of this case, 22 members of Congress wrote the Attorney General to ask whether what we're seeing with the Defend Trade Secret Act and the Economic Espionage Act, Defend Trade Secret Act was not yet in play, but there were the bills, whether there is something that's going on with national origin that's triggering some of these investigations. And it also led to Rochelle and I having the coolest epigraph in our paper that we could ever think of. So we included Red Hot Chili Peppers, psychic spies from China try to steal your mind's elation. So a lot of what we thought was going on when we looked at the messages that were being sent out was that unlike intellectual property in its raison d'etre of promoting progress in arts and sciences and hoping to build new knowledge, what we're seeing was the real push to keep the incumbent dominance of existing technology and not to let it spill and help the development of other competitors. We worried about that in itself, but I want to talk now about how it actually affects if we just think about, if that is our only goal, to keep our economic development going on, and I don't think it should be our only goal, but let's say that is some of us, it's our only goal is to keep economic development, economic strength of the United States, American innovation the strongest and the quickest that it can be, we still should be very worried about overprotection. So another article that came out around that time, the FBI was starting its strong messaging, was that American universities were infected by foreign spies. And this article talks about how universities should some of the times refuse funds, refuse students because they might be coming with hidden agendas. And they interview a professor at Colorado who said he's not taking any more visitors from China, any more graduate students from China. That's, you know, a no-go for him. And university research is really, when we talk about the numbers, some of the call that we have to ensure that we're making is for research and trade secret law is not to accept numbers just too easily. You know, $400 billion trade secret loss a year, and so we have this huge problem. We have to understand how these numbers work. Just like patents, I think, as well, when we talk about the price of pharmaceuticals and the gains. And a lot of the investments are coming from the public funds. And so they're different in kind from corporate investment. And so it's not clear that our only goal should be to internalize and to draw fences when we're developing new technologies that are in the context of research institutions. Now for the employment aspect. So as was already mentioned, the vast majority of all state civil trade secret lawsuits, and I think it's going to be very true with the Defend Trade Secret Act, the majority of these cases involve either an employee or a former employee or some kind of business partner or insider, former insider. In some count, it's over 90% actually of these cases involved. They're not about computer hacking, cyber security stuff, but it's really insiders that then leave. And the breach of the duty of loyalty or the breach of the contract are the improper means that you look for in misappropriation. And as Dennis Crouch said, the Defend Trade Secret Act is the shoehorn, will be a shoehorn for contract and employment law claims to become a federal matter. What does the Defend Trade Secret Act do? What does it do? It increases the stakes for employees, for former employees, and for their new employers to move, to hire, to recruit. It means that they are open to increased ease in civil litigation, to fines, to incarceration, if any of the information that's then used is deemed to be somebody else's, the previous employer's secret. It does, thankfully, thanks to Peter Manel, it does require that employment NDAs will have some notice about the whistleblowing immunity, but it's the exception that tells you about the rule. That otherwise, unless there's some kind of corruption, everything else will be enforced and is, will be actionable. And there's a big controversy, and there were some adjustments before the Defend Trade Secret Act was actually enacted about the adoption of the doctrine of inevitable disclosure, the injunction against threat and misappropriation. If somebody wants to take on a new position in a competitor, it's still to be seen how it will actually play out, and how it will be interpreted. But again, the language that was put in to give some assurances to people like myself who are cautious about creating these ex post de facto non-competes without a contract of them, and I think non-competes themselves are a great risk to economic development. There was a professor's letter that I'm signed on. I think we were, I don't know how many, 40 professors or so that were raising these questions. There were some adjustments put in, but again, I think a lot of the language is sort of nodding to the fact that threat and misappropriation will receive an injunction, that you can't move if there is a great risk that the employee will talk about their information later on in a new workplace. There's a nod there that says the order may not otherwise conflict with applicable state law prohibiting restraints. That's, again, a nod to the California prohibition on non-competes, which always has existed in California, the 16600. And so this is it's a good place to talk a little bit about how state variation has been not only interesting for corporations and allows selection effects and allows choice, but also kind of a researcher's dream, where you have the labs of experimentation of the states, and you can see what some differences, some exceptional policies in some states have done or have at least contributed to in those regions. And so I'll show you some message about this, but one thing that I want to tell you just before that, before we look at what happened in California with non-enforcing non-competes and definitely not enforcing the inevitable disclosure, trade secret doctrine. What I found yesterday when I was looking up some guide PowerPoints that attorneys are going around and talking about the Defend Trade Secret Act, this I actually just copy pasted from somebody else's PowerPoint that I don't know this person, but he says how to avoid becoming a defendant in the Defend Trade Secret Act. He says avoid patterns of hiring away your competitors' employees. Yeah, I mean, it's good advice for the purpose of avoiding litigation with a former employer, but it's really, really bad advice for creative competitors who want to compete on the best talent. And when you think about it, there was, some of you are familiar with the gentlemen's agreements that existed in Silicon Valley between Google and Steve Jobs orchestrated it from Apple, and Adobe and Pixar and Disney were all kind of, for 5 years, they agreed not to hire each other as employees. And they thought they were doing something great for themselves because they were depressing wages for sure. Every time there's no tournament over brains and talent, there's no retention efforts, and it's all with the sticks of confinement. But interestingly enough, when they approached, and Sheryl Sandberg is on record in these antitrust investigations, when they approached Facebook and said, do you want to be part of this gentleman's agreement of not hiring each other's employees? Facebook said, no, we're the best company in town. We're now the hot, sexy company in Silicon Valley, and everybody wants to work for us, and we want the best brains, and we're not going to, I mean, putting aside the fact that it's illegal to do that, but just to think about what we're trying to achieve with getting fresh blood, new blood into organizations and hiring the most experienced people who've already proven themselves in various fields, that's exactly what we want to do. We want to compete on each other's employees. And from the perspective of entrepreneurship, there's a very particular loss here, because the risks are even greater if you go at it alone. So if an employee, and again, we show this time and again, it's shown in the empirical studies about non-competes and trade secret enforcement, when an employee has to think about whether they will leave. So first of all, the greatest risk aversion effect is, I'm just going to stay even if I'm unhappy and underpaid and underutilized. But this next step is I'm going to move to another big incumbent who will indemnify me in the case of a trade secret litigation. To go at it alone and to hope that VCs will actually invest, they're out of there in the minute there's some kind of claim. That's much riskier. And this has really been one of the key concerns with the Trade Secret Act, the Defense Trade Secret Act. David Levin and Sharon Sandin, in an article that's called "Here Comes the Trade Secret Trolls," say that it's most likely to spawn a new intellectual property predator, a trade secrets troll, because again, you can file and just settle pretty easily. There's very low cost in this, and it's just a very scary thing to be a defendant, especially when there's a big imbalance in between incumbents and entrepreneurs or kind of established trolls wherever they are. And Yvette said in her talk that startups particularly will be vulnerable to this cost shifting that exists in the ex parte seizure provision. So that's, again, if you take the bigger picture of health of an economic ecosystem, entrepreneurship has a disproportionate positive effect on regions to infuse new kinds of competitors and competition, and that's part of not only Silicon Valley, but some other regions. So I had to put Biotech Beach here, which is where I live, where you see also other industries. It's not just, California has benefited, I think, not just in the tech industry, but in the pharmaceutical industry, where sometimes the pharmaceuticals will say, yeah, there's not real secrets, like the real hard investing, resource-intensive secrets in the software industries, but we really need the best, strongest protections. Well, and biotech as well, spillovers, positive spillovers and movement has been very beneficial. I don't know why this ended, but I have just a couple more slides about this. So one thing is that beyond California, what we know today is that even small changes in the laws, so in the laws of non-competes and trade secrets, if you code for the strength of enforcement, I probably have this slide, I can pull it up. So when you have, for example, some states that will interpret reasonableness in a strong way versus they'll say even more than 2 years of non-compete or trade secrets that are just in memory are not a trade secret. Even those kinds of smaller changes are very effective. Here, I'll just show you this. That too makes a difference in regional development. So you don't have to go all the way with rejecting non-competes as an enforcement tool. Even the line drawing with how we interpret the scope of trade secrets and the scope of misappropriation, whatever we define, can make a difference. And I think this is on non-competes. I think that this kind of exercise and this kind of empirical research is something that we really should try to do more of seeing how policy changes will affect the amount of investment in a region, the number of patenting activities that there are, the density of networks, which is something that we've been very fortunate in this field that we have a lot of business school professors and econ professors and psychology professors and organizational development professors that are all kind of across campus interested in innovation policy that are looking at these questions. With the inevitable disclosure doctrine in trade secrets, there are some studies that have shown that job mobility, just by enforcing the inevitable disclosure doctrine, by adopting it by some states, have depressed job mobility. But again, the research is pretty sparse in trade secrets, and I think there's a lot of room for more. But this is my last slide. I think it would be really important moving forward now that we have the Defend Trade Secret Act to remember that just like with other domains of intellectual property and beyond, with environmental policy, with our education systems, we have to think about our knowledge, information, talents, skills, know-how as part of a commons that contributes to everybody's success. And it will be critical to not over confine and to allow a lot of what we've always appreciated as leakage to continue to exist. Thank you.
And we've got time for questions, comments, if anybody's got them. And maybe I'll start. One thing, so if you go back to your last slide, and you don't have to, but thinking about, right, we do have this diversity among the states. And in a lot of ways, right, California, right, you can point to the economic engine there, and at least a lot of the evidence says, well, part of that is because of this, because of the legal structure. One question and so one impact from that could be, well, then we should make the law the same across the country. But there is another idea that maybe what works in California wouldn't work in Missouri, and maybe we would expect to have a different law in Missouri. And I wonder how your thoughts on that kind of element, and just the problem now we have with the Defend Trade Secret Act is that is at least a major step towards unifying the law, and so it's going in that direction.
Right. Yeah. No, that's a great question. So, there's several levels of in this question. So one is that the Defend Trade Secret Act unifies, but not completely, so because it doesn't preempt state laws. So what will happen with this layered scheme? I think that you're absolutely right that there's going to be a different equilibrium, optimal equilibrium for different regions. That's very clear, and it's clear also from the research that regions have a life cycle. What is appropriate when a region is just starting maybe is less desirable when a region has been established. Industries, different. I alluded to this. The software industry might have different needs from the healthcare industry, from the military contractor industry. There's going to be different needs and different kinds of line drawing that would be appropriate. And so I think it's a sort of a question that crosses most areas of law of how much we want to unify versus how much we want, kind of rules versus standards and all of these questions of multiple regimes versus one. The system will always be imperfect is I think one thing that we have to accept, and then we have to work with proxies. So one thing that I've been pretty confident with saying is that on the non-compete side, even though, sure, there's going to be times where some companies will want non-competes and will benefit from them. We know enough to say that it's such a big, harsh stick that we should move it aside and just do away with it. And then we're left with trade secrets, which kind of alternate and are the reasoning, the biggest reasoning about the legitimacy of non-compete. So now we're stuck with trade secrets. And there, I've never thought, and I continue to think that, of course we need trade secret law. Of course there are many, many things that we want to protect and define as trade secrets. So I think what I would want to know more, I don't think that I necessarily, that there's necessarily different states that need different regimes. What I think we need is to know more about the effects of the different policies on growth in general. And I think that the Defend Trade Secret Act passed with relatively little debate. When you compare it to all the hearings about the patent reforms, it was really virtually nothing, and a lot less empirical evidence. There was really just like surveys that shows that we were already in the United States, I think at a 4.5, there's a scale of 5 in the protection of trade secrets. And before the Trade Secret Act, we were very high up there in enforcing trade secret law. I worry about the loss of the kind of experimental from the knowledge building and kind of having some choices. Not so much because I think that Missouri has different needs than industries will have different needs, but I don't know that different states will have different needs than others. Yeah.
So the Computer Fraud and Abuse Act defines what is being protected as anything of value. Does the DTSA help narrow the definition of what a trade secret specifically is, and how will it relate to other acts that are kind of targeting the same thing?
Right. No, so the Defend Trade Secret Act adopts the Economic Espionage Act trade secret definition, and I think it's broader in some ways than the Uniform Trade Secret Act. So it says things that are just in memory. It basically is all inclusive, and it includes what Dennis presented in the morning, just kind of the two questions of whether it's secret, and it's not. It doesn't exempt, or you don't have to choose between these different statutes. So in and of itself, it's very, very broad, and I don't think it helps clarify any of the other cyber laws. Yeah.
So back to basic policy, patents have the advantage of getting information out into the public. Trade secrets tend to keep it, as it says, secret. So it seems like, and there have been different discussions here today, that our emphasis on patents has diminished, especially Supreme Court and the America Invents Act. While you just mentioned that trade secrets already were at kind of a high level, and now with things like the Defend Trade Secret Act, it's even more of an emphasis. I guess I got a couple part question. One, why? Is this something? Is it reflecting something that's going on that is pushing these two opposite directions? Is it conscious? Is like a particular industry or a group of lobbyists supporting this kind of recalibration? And then, I don't know if you would venture on this question, is it a good thing, neutral thing, or a bad thing?
Yeah. The
I
$1
don't know if
million
that's too much.
questions, right? Yeah. So So those are the big questions. I think with patent law, there was much more of discontent by some of the, big incumbents that they saw kind of the patent thicket happening, and there was a push for. There was much more evidence of trolling, of the costs of litigation. Not that they weren't benefiting a lot of these tech companies, but there was kind of a concerted effort and evidence that we need to tweak, and patenting is alive and well, of course. But there was also much more of a public debate. On the human genome, for example, there was the ACLU came in in an amicus. There's kind of an understanding that we have to all the time balance the rights of the patent holder, the rights of the competitor, and the rights of the public, and we're always in that domain of balancing. I think with trade secrets, for whatever reason, there's much more of this kind of buying into the property framework of maybe because it's sort of a self-help type of intellectual property that's covert. There's much more of this ownership idea, and not as much of an understanding of how it's a balance between the control and the flow. I do think, and this is what Rochelle and I argued, and Rochelle Dreyfus is a professor at NYU Law School, and she's actually much more savvy about all of the Economic Espionage Act history than I am. She actually, when it was passed, she had written a few articles about it in 1996, and when the Economic Espionage Act passed, there was already a lot of controversy about becoming a federal law. And trade secret was always the province of the states, and because there was worry about it, and because there wasn't that bargain of enablement and disclosure, there was a bargain that was reached that for the first 5 years, any prosecutorial activities would be approved by the Attorney General. And since then, that's kind of long gone. There were a lot of statements that would be just very, very limited, the usage of it. But we haven't seen that happening at all. And we've become, politically, we think that there is something, and I alluded to this, that there is something that's very much about the competition between countries. So, I mean, this is a political climate right now, and I think Yvette was referring to, she said whether a wall is physical or a wall is in what?
Robin's efforts.
We're pointing to the screen.
Yeah,
Robin. Okay, I thought, okay, yes. On Skype, she said that, the wall. So it's all part of, these questions of who will be the next dominant actor in technological innovation. And I'll just tell you one anecdote that Rochelle and I kind of got chills from. So there's the trilogy of films that have been produced. And I show this to my students. I show The Company Man to my students. And The Company Man has this very regular storyline, and it's based on these cases that they've prosecuted, where there's this sort of lowly engineer. He's very underpaid in his company. He's been working there. He's the company man. He's been working there for years. And the film, it's designed to warn against that call that he gets by a headhunter that maybe he's desired elsewhere. And he comes to his, he ends up being the hero of the story because he reports these recruiters and he's part of a sting operation, but he never gets, a raise, or his talents are not really used. But the point about The Company Man is that the first scene of the story, or the film, is a burning building in Shanghai. And you see people burnt alive. Like, this is the imagery that the FBI is using. People burned alive because they don't have the technology for this metal, aluminum that would have prevented many deaths. And that's how it starts, because it's telling you that there's like this kind of ominous Chinese music that the FBI put. And these are actors that they hired and everything. And they tell you they want our technology. And we would think, and Rochelle and I would talk about this, you know, we would think that this would actually not be the most sympathetic case for the American. Don't give them this technology that would prevent all these deaths. But the idea is we have something and we need to keep it here. So that's, I think, part of the global political story. Yeah. Go ahead. Dennis, do you want to call on before?
Right, no, and let's do one more,
Okay.
just one more question, which now we have competition. Because we're running at our endpoint, and we can have.
You mentioned Flash Boys, and in that book, the Russian hacker, or not the Russian hacker, the Russian coder gets put on trial by his industry-wide mates, and essentially found not guilty for what he was found guilty for. Has anyone ever gone to like more of an industry standard across? You mentioned going to an industry standard. Has anyone gone to that? That's killing me over there. Sorry. Has anyone gone to an industry standard as far as trade secrets, and what is that rendered, I guess?
What do you mean by industry standard?
Well, like, they found because he was sending his code to himself through Google Docs and doing those things, and they were all like, hey, this is fine, this is what we normally do, and you can take that to your next, this is generally what happens.
But that's not why it was overturned. So, so you're absolutely right that Aleynikov did something that had been the practice of programmers always. He felt like he was keeping a notebook. Michael Lewis becomes convinced, he gathers his panel of post-trial experts and becomes convinced it was mostly open source that he used. There was no secret sauce that would have hurt Goldman Sachs, and that he actually had no intention to use it. It was part of his industry practice of just, he wanted to remember where were those open source places that he went to, but that his new employer would not, they were going to start something from scratch and they would not have benefited at all from all that. But the reason, that's all of that, I think it's a great question, because all of that had nothing to do with the fact that the case was overturned. Actually, all of that practice is very much illegal now, and I know people who know Aleynikov who went to MIT with him, and they're super afraid of any kind of that practice of emailing yourself something, of ever revisiting something that you programmed. It was turned on the technicality of the fact that it said products versus it didn't have services, and that's what Congress reformed, and intended for use, it was not in it. And post-trial, so what happens, and this is also, I think, alarming, the whole file is taken to the state courts, and then it's prosecuted under the New York criminal law statutes, because they really didn't want to give up this case. So I guess if your question is whether we should adopt industry standards of sharing information and helping each other and being reciprocal, and Eric von Hippel at MIT has done a lot of work on this, on how engineers have these norms of, even when they're working for competitors, they'll call somebody up and come help each other, and that's how the industry moved quickly together. That's not at all what we got with the Defend Trade Secret Act.
That's where we got to stop. Thank you very much. This is really great.